Negotiable Instruments Act 1881. Three types of negotiable instruments: promissory note, bill of exchange, and check payable to order or bearer. Capacity of contracting is enough for making the bills or negotiable instruments. Minor also can draw, but he will not bind himself. Agents are authorized for specific functions of accepting, endorsing specifically and separately. Promissory note is an instrument containing an unconditional undertaking to pay a certain sum of money to a person or to his order or to the bearer of the instrument. Bill of exchange is an instrument of unconditional order directing a person to pay a certain sum of money to or to the order of a certain person or to the bearer of the instrument. Check is a bill of exchange drawn on a specified banker, payable on demand, and includes the electronic image of a truncated check and a check in the electronic form. Check in electronic form signed in a secure system with digital signature, truncated on generating an electronic image substituting further physical movement during clearing. Check is deemed crossed generally where it bears across its face between two parallel transverse lines words "and company, not negotiable" or "account payee." With addition of the name of a banker, the check shall be deemed to be crossed specially. A person taking crossed check bearing words "not negotiable" shall not be capable of giving a better title. Where a check is uncrossed, the holder may cross it generally or specially. Where it is crossed generally, the holder may cross it specially. Where the check is crossed generally or specially, the holder may add the words "not negotiable." When crossed generally, the banker shall not pay it otherwise than to a banker. When crossed specially, the banker shall not pay it otherwise than to the banker to whom it is crossed. In respect of a bill of exchange or check, the maker is called the drawer and the person who is directed to pay is called the drawee. Drawee in case of need is a person whose name is given in the bill or any of its endorsements in addition to the name of the drawee to be resorted to in case of need. The drawee of a bill becomes an acceptor when he signs his assent and delivers the document to the holder or to some other person on his behalf. A person who accepts a bill after noting or protesting for the honor of drawer or any one of the endorsers is called acceptor for honor. Payee is the person who is named in the instrument to whom or to his order money is directed to be paid. Although observed rarely, negotiable instrument may be made payable to two or more persons jointly or one of two or one or some of several payees. The terms "at sight" or "on presentment" in respect of promissory note or bill of exchange mean on demand. A check is always payable on demand, while a bill of exchange or promissory note will be payable on demand when no time for payment is specified in it. The term "after sight" in a promissory note means after presentment for sight, and in a bill of exchange it means after acceptance. The date on which a promissory note or bill of exchange falls due is called its date of maturity. The maturity of a promissory note or bill of exchange not payable on demand, at sight, or on presentment is on the third day after the day on which it is expressed to be payable. A bill or note payable so many months after date shall terminate on the day of the month which corresponds with the day on which the instrument is dated, or it is presented for acceptance, or if the month has no corresponding day on the last day of such month. When the maturity is on a public holiday, the instrument shall be deemed to be due on the next preceding business day. Public holiday includes Sundays and any other day declared by the government. When an instrument can be construed either as a bill of exchange or as a promissory note at the discretion of the holder, that instrument is called ambiguous instrument.
When amounts stated in words and figures differ, what is stated in words prevails.
A stamped instrument which is incomplete in respect of the amount and it permits the holder to fill up the amount within the specified stamp eligibility is known as inchoate stamped instrument. Presumptions under section 118 that the negotiable instrument was for consideration and the instrument was made or drawn on the specific date as mentioned, and it was properly stamped, and every bill of exchange was accepted before its maturity, every transfer was made before its maturity, and endorsements were made in the order in which they appear thereon, and the holder is a holder in due course. A negotiable instrument not supported by consideration is a nullity, but if it is transferred to a holder in due course, such holder and every subsequent holder may recover the amount on the instrument. A holder of a negotiable instrument means any person entitled to the possession of that instrument in his own name and to receive the amount due from the parties thereto. When a negotiable instrument is lost or destroyed, holder is the person so entitled at the time of such loss or destruction. A holder in due course means any person who for consideration became the possessor of a negotiable instrument payable to bearer or became the payee or endorsee if the instrument is payable to order before the amount became payable, and he has no cause to believe that any defect existed in the title. Payment in due course means payment in good faith and without negligence in accordance with the apparent tenor of the instrument to any person in possession under circumstances which provide a ground to believe he is entitled to receive the payment. A negotiable instrument is stated to be negotiated when the instrument is transferred to any person so as to constitute that person to be the holder thereof. When the maker or holder of a negotiable instrument signs on the back or face of the instrument for the purpose of negotiation, he is said to endorse the instrument and is called the endorser. When the endorser adds a direction to pay the amount to or to the order of a specified person, the endorsement is said to be in full and the person so specified is called the endorsee. If the endorser doesn't indicate the specified person's name, the endorsement is said to be in blank. An endorsement in blank can be converted into endorsement in full when the holder writes above the endorser's signature a direction to pay to any other person as endorsee. The making, acceptance or endorsement of a negotiable instrument is completed by actual or constructive delivery. Delivery has to be made by the party making, accepting or endorsing or by a person authorized by him. A negotiable instrument payable to bearer is negotiable by just delivery. A negotiable instrument payable to order for negotiation requires endorsement and delivery. Endorsement transfers to the endorsee the property along with the right of further negotiation unless restricted otherwise. Different types of endorsement. Blank endorsement, where it becomes payable to bearer, Under special endorsement, it writes the name of the person who will receive the payment. Under restrictive endorsement, it restricts further negotiation by way of not negotiable. Under conditional endorsement, sans recourse talks of no recourse to the endorser. Under sans phrase, there is a restriction that no expenses shall be covered by the endorser, and facultative endorsement abandons certain rights of the endorser. A negotiable instrument can be endorsed and negotiated by every sole maker, drawer, payee or endorsee, or all of several joint makers, drawers, payees or endorsees. Where an endorser excludes his liability on the instrument and afterwards becomes the holder, all intermediate endorsers are liable to him. Where an amount has been partly paid on an instrument and a note to that effect is endorsed, such instrument may be subsequently negotiated for the balance amount. A negotiable instrument may be negotiated until payment or satisfaction thereof. It cannot be negotiated after such payment or satisfaction. Where no time or place is specified for presentment, a bill of exchange payable after sight must be presented by a person entitled to demand acceptance within a reasonable time in business hours on a business day. In default, no party thereto is liable to the person making such default. A promissory note or bill of exchange made payable at a specified period after date or sight thereof must be presented for payment at maturity. Where a promissory note is payable on demand and is not payable at a specified place, no presentment is necessary. A promissory note payable by installments must be presented for payment on the third day after the date fixed for payment of each installment. Non-payment on such presentment has the same effect as non-payment of a note at its maturity. A promissory note or bill of exchange payable at a specified place must be presented for payment at that place. A promissory note or bill of exchange not made payable at a specified place must be presented at the place of business, if any, or at the usual residence of the maker, drawee or acceptor. Where the drawee, maker or acceptor has died, presentment made to his legal representatives. Where he has been declared an insolvent, presentment to his assignee. Delay in presentment is excused if the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct or negligence. Presentment is not necessary in certain cases if the maker, drawer or acceptor intentionally prevents, or any party sought to be charged has engaged to pay notwithstanding non-presentment, or the party promises to pay and waives right to take advantage of any default, and if the drawer could not suffer damage for want of such presentment. Where due notice of dishonor is received by the drawer, he is bound to compensate the holder in case of dishonor by the drawee or acceptor. Maker of a promissory note and the acceptor of a bill of exchange are bound to pay the amount thereof at maturity according to the apparent tenor of promissory note or bill of exchange. Banker, having sufficient funds of drawer properly applicable to payment of such check, must pay the check when duly required. In default, he must compensate the drawer for any loss. A legal representative of a deceased who signs his name to a promissory note or bill of exchange or check is personally liable unless he expressly limits his liability to assets received by him. Whoever endorses and delivers a negotiable instrument without expressly excluding his own liability, he is bound to every subsequent holder in case of dishonor. Every prior party to a negotiable instrument is liable to a holder in due course until the instrument is duly satisfied. Three modes of discharge: by cancellation, where holder cancels acceptor's or endorser's name with intent to discharge him; by release, where the holder discharges such maker or acceptor or endorser after notice; or by payment to all parties thereto as payment in due course of the amount due. Where no rate of interest is specified, interest calculated at 18% per annum until realization of the amount. Check originally payable to a bearer, drawee is discharged by payment in due course to the bearer, notwithstanding any endorsement appearing thereon. If holder of a bill of exchange allows more than 48 hours exclusive of public holidays to the drawee to consider whether he will accept the same, all previous parties not consenting to such allowance are discharged from liability to holder. If holder of a bill of exchange acquiesces in a qualified acceptance, all previous parties whose consent is not obtained to such acceptance are discharged as against the holder. Unless it was made to carry out the common intention of the original parties, any material alteration renders the instrument void as against one who is a party at the time of making such alteration and does not consent thereto. When a negotiable instrument is materially altered but doesn't appear to have been so altered, paying it according to the apparent tenor thereof in due course shall discharge such person or banker from all liability thereon. A bill of exchange is treated as dishonored by non-acceptance where the drawee makes default in acceptance, or where the drawee is incompetent, or where the acceptance is qualified. It is considered as a dishonor of the instrument when the maker of the note, acceptor of the bill, or drawee of the check makes default in payment upon being duly required to pay the same. When dishonored by non-acceptance or non-payment, the holder must give notice that the instrument has been so dishonored to all parties whom he seeks to make liable. Notice may be given to a duly authorized agent or to the legal representative or assignee. It may be oral or written, but must inform that instrument has been dishonored and why it has been dishonored, and he will be held liable thereon. It is given within a reasonable time after dishonor at the place of business or residence of the concerned party. Dishonor notice is not necessary in some cases where dispensed by the party entitled to notice, where the drawer himself has countermanded payment, when the party entitled to notice cannot be found after due search, when the acceptor himself is a drawer, and when the party, knowing the facts, promises unconditionally to pay the amount due. The holder has to get the dishonor noted by a notary public upon the instrument within a reasonable time and specify therein the date of dishonor, reason, and the notary's charges. And such certificate of noting by a notary public is called protest. Where acceptor becomes insolvent before maturity, the holder may cause the notary public to demand better security and cause such facts to be noted and certified, which is called protest for better security. Remedy under section 38 is available when the check drawn by a person is for discharge of a legally enforceable debt or other liability and is returned by the bank for reasons of credit not sufficient or exceeds arrangement. Such person shall be deemed to have committed an offence and shall be punished with imprisonment for a term which may extend to 2 years, or fine which may extend to twice the amount of the check, or with both. Requisites for application of section 138 are mainly the check has been presented within 3 months or before validity, whichever is earlier. The holder makes a demand by giving a notice in writing within 30 days of return of the check, and the drawer fails to make the payment within 15 days of receipt of the said notice. Where the entity committing an offence is a company, then Every person, director, manager, secretary or other officer who at the time the offence was committed was in charge of the conduct of business as well as the company shall be deemed guilty. Exemption is if the concerned person proves the offence was committed without his knowledge or he had exercised due diligence to prevent it. Nominee directors from government or government financial corporations not liable for prosecution under this section. Defined in section, the three instruments, parties, content from promise to pay, order to pay and order to pay, liability of maker or drawer, primary or secondary, crossing applicable only to checks, stamping not applicable to checks, payable to self only in respect of checks, criminal liability under section 138 for checks, acceptance relevant only for bill of exchange, days of grace for bill of exchange and promissory note, drawee bank only in respect of checks, pre-printed stationery for banks in respect of checks, notice of dishonor necessary in case of bill of exchange, in case of checks bank advice enough, acceptance relevant for bill of exchange and not applicable in other two cases.